We're going to talk about patents, trademarks, copyrights, and trade secrets, primarily to give you a little bit of background on these various areas of legal protection. And hopefully you'll know a little bit more when I'm done. Not so much that you're going to be an expert in the field, but hopefully you'll be at a point where you can say, I know enough to ask questions. Do I have something that maybe I should be concerned about? Something that I should possibly protect? And one of the first things I'd like to do is talk about the differences between some of the protection. A patent covers an invention such as a pump, a drug, computer circuit, things of that nature. The patent rights only exist after a patent has been granted by the U.S. Patent Office. Patents cover the concept that is described and claimed in the patent. The patent is a contract between the inventor and the U.S. government. The inventor discloses the concept in great detail, and in exchange for that disclosure, you get a patent, hopefully, that gives you a limited monopoly for a period of time. On the second slide, there is a copy of a patent, and you can see it has a title. There's an inventor, the company that owns the patent. There's some classes where the patent was categorized by the U.S. Patent Office. And down here are various patents that were cited during the prosecution of the patent, that these were relevant prior art patents. And you can see up here is the date that the patent was issued, and this patent has been issued long enough ago that it is now expired. Next, we're going to move to trademarks, and trademarks cover designators that can identify the source of a product or service that is sold. Good examples of trademarks are things like Clorox, Coca-Cola on the product side, Avis and McDonald's on the service side. The rights in a trademark are developed by actually using the mark in connection with the products or services that are sold. The trademark rights extend only to the types of goods or services that are actually sold under the mark. Trademarks allow consumers to differentiate between various goods and services that are offered, and the trademark rights continue as long as the trademark is used in association with the goods or products that are sold. On the screen over here, you can see this is a trademark registration. It's owned by Owens Corning Fiberglass Corporation. I think they go by Owens Corning now. It's for fibrous glass residential insulation. And in this particular case, this trademark is for the color pink. We helped Owens Corning get that trademark many years ago, and at the time it was one of the first colored or trademarks that were granted on a color. Very difficult to get and was kind of a landmark trademark registration for Owens Corning. Next, we're going to move to copyrights, and copyrights cover material that has been created by an author, such as books, music, motion pictures, advertising, computer software. Copyright doesn't cover the underlying concept. It just covers the way that you've expressed the material that you're presenting. An example of that, you could go to a university bookstore, get several books that teach calculus. They all will teach calculus in basically the same manner, may have a lot of very, very similar material in it, but each book is an individual creation by that author, and each one can be covered by copyright protection. Again, the copyright goes to how the author presented the material, not the underlying concepts. Copyrights last for a long time. The life for an author is, an individual is 50 years. For a business, it's 75 years from the date of publication, or 100 years from the date of creation, whichever is the shorter. Copyright gives the owner the ability to copy the work, to publish the work, and to perform the work. Next, I'm going to give you a little background on trade secrets. A lot of people think they have trade secrets. I've had a lot of clients that have said, oh, we've got all these trade secrets. I frequently shake my head and say, well, you probably really don't have any, but let's talk about it. To have a trade secret, you have to actually do something to protect the trade secret. You have to restrict access to that information. And we're talking about access to external sources and also internal sources. If you have a trade secret and you let everybody in your plant come and look at the material, everybody that works there can come and walk by and see what's going on, ask questions about it, you probably don't have a trade secret. If you've done stuff to protect that trade secret where you've limited access, and again, even access internally within your company, you may have a trade secret. Confidential disclosure agreements, confidentiality agreements can help protect your trade secrets. But again, they have to be structured in a way that they really protect the secret, and most times companies put together CDAs, they have a standard form, somebody comes in, they sign it. There's nothing really specific about getting trade secret information, and most of the time those agreements are really not very effective. In today's world, it's difficult to protect trade secrets. Employees are very mobile. People come, work at your place for a few years, they leave. More than likely, if you haven't restricted access to trade secrets in your business, those trade secrets go right out the door with the employee. A lot of people now work from home. It's even harder to control access. The employee isn't sitting in an office somewhere where you know what they're doing on a daily basis, have access to their computers and other things. They're working from home, makes it much, much harder to control trade secrets. Most of the time, the protection that we see that gets put in place for trade secrets, it is against former employees. Somebody leaves, they take their computer with them or files off of the computer. It's fairly easy to track that stuff down. There is a lot of litigation with that. It is possible to get those employees to bring that material back. It's much harder with third parties, companies that have come in and maybe seen your material, or you had a confidentiality agreement. Now they're walking away with the material. Much, much harder to enforce those. You don't see much litigation on that. Next, I'm going to move into a little bit of detail about the various types of protection. We've kind of set the stage for what's available. Now we're going to talk a little bit more. I'm going to talk a little bit more about what each one of these does. In patents, the patent standard is something must be new, useful, and unobvious. Kind of an unusual terms. Almost everything is useful. Don't worry about that. That's an easy standard. The novelty is that the newness is that it has to be different than what's been out there before. The hard standard is that it has to be unobvious from what's been done before. And that's usually where most of the battle is in the patent office. The invention that you've come up with, is it unique enough that it is unobvious over what's been done before? The patent office applies these standards. If you file a patent application, it gets examined. You go back and forth with the patent examiner. I pointed out earlier where there were in the issued patent that was on the screen a few minutes ago, the various references that were cited. The patent examiner will do a search and find various things that he thinks is close to what you've got in your patent application, and you'll have to distinguish your technology over those prior patents. Most of the time, people want to know how they can determine if something is patentable. Almost every client that comes in, they'll say, well, gee, how do I know if this is patentable? Obviously, we can do things like patent searches and see what's out there. But my first response to that is, what are you doing with this technology? Is it solving a problem that's in your industry? Is this making something cheaper, better? If you can tell me that this is a big advancement in the industry that you work in, now I'm interested. You've given me some indicators that you've got something that has potential for patentability, and we ought to take a hard look at it. So usually the people, the client, the inventor, the owner of the company, are the best indicators on whether or not something is in fact going to be patentable. Another thing that you can do with your patented technology, it is possible to license it and sell it to others. And I've seen many cases where patents have actually enhanced the value of a company. People have come in and asked, gee, I want to buy your company. What protection do you have for the technology that you tell me that is so important and critical to your company? If you don't have any patent protection on it, it just kind of dropped down a little bit in importance for that company. Same thing with trademarks. If you don't have anything protected oh, we've got these wonderful identifiers. Well, you don't really have them protected. Again, the value drops a little bit. One of the things we can do to determine if what you have is patentable, we can do patent searches. We go into the patent office, their computer system, see what else has been done. The United States is a first-to-file system. It used to be a first-to-invent. Now it is a first-to-file. So if you come up with some new technology, it's important that you file fairly quickly. You don't want to wait and see if anybody else is doing anything in this field. If somebody files before you do, they have the priority. They will get the patent on it. So if you have new technology and you think it's significant, don't sit on it. Do some evaluating. Decide whether or not it has enough value that you should move forward with it. If it does, I would say do that, don't wait. Waiting can be disastrous. Okay, now we're going to move to some more detail on trademarks. There are state and federal trademark laws. The state trademark laws really don't mean much anymore. The only time that the state registrations meant anything is if you had a very geographically limited business. In today's world with the internet and websites, hardly anybody has geographically limited businesses, so the state trademark rights don't really mean much. The federal registrations cover all 50 states. It does provide constructive notice to everybody that you have a trademark. It puts you in the federal system. It gives you the ability to go to federal court, and it's a lot harder for someone to say, gee, I didn't know that was your trademark that I'm using now. If you have it registered and you put a circle R after it, it makes it a lot easier to say that, yes, that's my trademark. You know, there's no way you could innocently adopt that trademark. You would develop the rights to the trademark through using the mark. It doesn't exist until you actually use it. You can file on an intent to use basis where you're saying, gee, I'm coming up with this new trademark, I'm not quite ready to use it yet, I will file on it, but you will never get a registration until you actually use it. So use of the mark is very, very critical in creating your trademark rights. The trademark must be capable of identifying the source of the goods or services. It covers a specific area that where you sell. Classic example in this, Champion Spark Plug was a very successful company. I think they still make Champion Spark Plugs. Trademark was known throughout the world for spark plugs, and they had a registration for that. Very successful trademark. Well, there are other Champion registrations. Champion Clothing has the Champion mark, and they sell all kinds of clothing under it. I think there's Champion batteries, there are Champion windshield wipers. Champion didn't extend its product line enough. They were pretty much constrained to spark plugs. That's all they ever sold under the trademark. So these other companies came in and created rights to Champion for other products, and that can happen to you. So you want to be careful if you have a strong trademark and you plan to extend that trademark to other things. You might want to go out and file intent to use trademark registrations or create some use that will give you a basis to file before other people jump in and start eroding away your ability to protect that trademark. Next, we're going to talk a little bit more about copyrights, and what can be covered by a copyright must be original or independently created. It must be in a fixed medium that is subject to being copied. Copyright, again, doesn't cover the underlying concept. It covers how you've expressed that material, the way you've presented it. Copyright registration gives you the right to keep others from copying your material, and it gives you the procedural advantages of being in the federal copyright system. Copyrights don't exist until you file something. You have a copyright in anything that you create, but if you want to have legal rights to it, you have to invoke the federal copyright laws and file a copyright application. Until you do that, you're not part of that system. We've talked about the life of the copyright before. I won't go through that again. It's not mandatory that you put a copyright notice on material that you create, but I always recommend to clients that they do that. It doesn't cost you anything, and it puts people on notice that you're claiming copyright in this material. For the people in this room, probably the most likely place you will have copyright protection will be an advertising material that you create, possibly computer software that might be created for things that you were going to use in your company. And again, putting a copyright notice on the C in a circle, the year the material was created, and the name of the company or individual claiming protection is real easy to do, and it doesn't really cost you anything, and it has the ability to keep others from hopefully just saying, I can copy that. You want to be careful with your copyright. If you hire people to do things for you, you have an ad agency that produces material for your company that you use in advertising and promoting your products and services, make sure you have a contract with them and that contract is very clear who owns the copyright in the material that is created. I can't tell you the number of times I've had calls from businesses, frequently extremely big businesses, and the conversation will go something along the line of, we just fired our ad agency and told them to send over all of our material. And they said, what do you mean your material? It's our material. And they'll say, they're not right. Isn't that correct? At that point, I'll say, okay, what kind of a contract do you have with your ad agency? And frequently the answer will be, we don't know, or we don't have any. And I will tell you now, we're in a negotiating stage. The ad agency created the material. They own the copyright until it's transferred to somebody else. And if you didn't have an agreement that required them to transfer it to you, they still have real rights to that material. The good news is that with most ad agencies, you can negotiate something and get rights to the material that you think you owned and the material that you want to use. Also, if you do hire somebody to create material for you and you've used it for a while and you're no longer using that vendor and you want to change the material that they gave you, you don't automatically have a right to do that, again, without a contract that gives you those rights. They can say, we created this, you don't have the right to do what's known as derivative works. That's something, if you want to do that, you can come back, we'll do it for you, you can pay us, or you can pay us to give you the right to do that. So be careful when you're out using vendors. The copyright area is an area you can get caught very easily, and something I think you want to pay more attention to as you go forward. And again, if you're using material from other people, other sources, have permission to use it or don't use it. Now we're going to move on to trade secrets. Again, I think earlier I expressed that I'm kind of skeptical on whether companies really have trade secrets or not. If you're going to have a trade secret, you better identify what it is. And I think most companies would be very well served if they would sit down and literally do an inventory of what they consider to be their trade secrets, document that in some way, and make sure they're taking steps that protect those trade secrets. If it's something that's really important to you, I don't think you should let other people come in and look at it. Again, that's very, very difficult to claim it's a trade secret, especially if you let anybody that comes in the front door that signs a confidentiality agreement have access to it. If you say, gee, we had two people that came in, two other companies, we had them sign confidentiality agreements that were very specific, acknowledged that this was a trade secret of our company. They were only getting access because there was a relationship that we needed to establish with them to do work in this area, and it was critical that they have access and we protected it. Okay, maybe your confidentiality agreement now works. But if it's the one that you have for anybody that walks in the front door, I don't think it's going to get you there. The same thing would apply to employees that you have that work with your trade secrets. Consider having a separate confidentiality or an employment agreement for those employees, something that recognizes that they're actually working with trade secrets. This is important to your company, and that you've taken steps to protect that information. Again, if you don't do that, it's much, much harder to claim that you have a trade secret. And again, if this is important to your company, you have to take those steps to protect it. And in most companies, it's very, very difficult to screen off areas of the company and say, this is where our trade secrets are kept. These are the few people that have access to that information. Other people can't go in there. That's difficult to do. I understand that. But at the same time, if you want to consider those to be trade secrets and to be in a position where you can protect them, you have to do things like that. And if you don't do it, your ability to protect those trade secrets is basically zero. There is a Uniform Trade Secret Act that provides some protection. It was created and then various states have adopted versions of it. It is possible to get injunctions against people that have taken your trade secrets. It's possible to get damages. It's possible to get attorney fees. But again, you have to prove your case that you had a trade secret and that you've taken all the steps to protect it, and that's a tough battle. And I also will tell you that if you're litigating somebody who has taken your trade secrets, to a great extent, it's already too late. The trade secrets are out. They may not be able to be pulled back and put back into that trade secret category. You're taking remedial action. Again, it's a little bit like locking the barn door after the horse has been stolen. The trade secret's gone. It's hard to put it back and get it back to where you were before that happened. So be very careful with your trade secrets. I know, again, a lot of companies allege that they have trade secrets. Oh boy, these are very valuable and important to our company, but very few companies really protect them. Again, using Coca-Cola as an example, I've used them several times today. The formula for Coke has always been held out to be a trade secret. Very few people have access to it. I'm not sure whether you can reverse engineer what that formula is from the actual product or not, but Coca-Cola treats it as a trade secret. And I think there's a handful of people at any one time that ever have access to that information, and they're very serious about it. That's a trade secret. If you don't take steps like that, you probably don't have a trade secret. I've gone through this fairly quickly, trying to give you a little bit of information on basically the various protections that are available in the intellectual property area, what you have to do to invoke those protections, and hopefully I've given you enough information that when these issues come up in your companies, you can say, okay, I understand a little bit about that. I think we may have something that is subject to patent protection, trademark protection, copyright protection, or trade secret. I should probably go talk to somebody and either formalize that protection or do something, but hopefully it puts you in the position where you can make informed decisions that I know enough about this, I ought to do something and move forward with that type of discussion. Almost all of the decisions in this area are driven by economics. Does the technology or the information, the trademark, have enough value that it's worthwhile protecting? I tell clients all the time that if we have an invention and we've done a patent search on it and it looks like it's 100% patentable, but you can't sell it, who cares? It doesn't have any value to your company. At the same time, if we do a patent search and we say, gee, it looks like it's about maybe 10% patentable, and you can't make them fast enough, and everybody wants one, and you sell them like crazy, and you make a lot of money off of every one you sell, boy, let's go file a patent application on that. That's important. That's valuable to your company. And I think that's what should drive all of the decisions in this area. Are you getting something back? You're going to spend some money, but if you do it properly, you should get a lot more back. It should create value for your company, and it should drive the system. They should be fairly easy decisions. This is something we've evaluated, and we think this does a lot more for our company than it's going to cost to protect. If you're on that side of the evaluation, I think you're in the right place, and you ought to take some steps and move forward. Again, if it's something that doesn't do much for you, even though it might be protectable, why bother? You don't need to have a patent to put on the wall of your office unless it does something for you.